Welcome back, folks. This is Joint Justice Oversight Committee. I'm used to saying this. We used to say my committee, standing committee name. This is July 16th, and we're continuing our committee meeting today, and we're shifting gears this afternoon. We're talking about pretrial supervision. Is an initiative that we put in place last year. It was a change in statute in terms of when folks are going through the court system. This is before they are sentenced. They could be released back to the community on conditions. And this is putting in a new program that would allow them to be supervised, and they will be supervised by Department of Corrections. So Ben's going to go quickly over the statute that we put in place. Some of you have already seen this, others this may be new. And we also have folks from the Council of State Governments with us, who we've had a partnership with them for a number of years, working on corrections issues and justice reinvestment, to really look at this program and see how it's working, what is working. They may have some recommendations in terms of what needs to change in order for it to work better. Last year, we allowed 2 counties to take part in this, and I can never remember what the counties were. One is Essex and Orleans. We put in for funding, I believe, around $600,000 for this a couple of years ago, not this current fiscal year, but the previous fiscal year. And we gave approval in this committee to have sort of a pilot project in Essex and Orleans County for the initial rollout of this program. So Ben, if you could quickly walk us through the current statute.
Sure.
Then we'll shift gears to Council of State Governments.
For the record, Ben Novogrowski from the Office of Legislative Counsel. Forgot to do that this morning. So quickly going through the pretrial supervision program. It was established and is governed by 13 VSA 7555. It can be imposed as a condition of release under 2 provisions of 13 VSA 7554. There's certain eligibility requirements for placement in the program. It's a court-ordered program, and the court determines the eligibility of those defendants. DOC administers the program, so they conduct the supervision, and which is determined by their own evidence-based screening process. And there's also a compliance and review procedure once you're in the program. So again, going into the governing statutes, 7554 is often referred to by our prosecutors as the bail Bible. This is the condition of release statute, which governs release prior to trial. There are various factors to determine if conditions of pretrial release need to be imposed on a defendant. I'm going to leave this for you to go through on your own, but there are a series of factors. Pretrial supervision is added as a condition, which is, again, governed by 7555. And the purpose of the program is to assist those who are eligible through the use of evidence-based strategies to improve pretrial compliance with conditions, to coordinate and support the provision of pretrial services, and to ensure attendance at court appearances, and to decrease the potential of recidivism. So a multifaceted approach of the program. So what's the eligibility criteria? Really 2 criteria. 1, the defendant has to be accused of violating conditions released pursuant to 13 VSA 7559, which is the statute to impose sanctions for such violations, or the defendant has to have at least 5 pending court dockets against them. So that was a policy choice that was made to not overload the system, which was a point of concern for the legislators discussing this. And so that's why these 2 eligibility criteria were established. What is the procedure? So at arraignment or a later hearing, a party or the court may move to determine whether someone's appropriate for placement in the program. The review is scheduled upon receipt of a DOC report containing recommendations about the the suggested levels of supervision for the defendant. Then the court reviews the report, schedules a hearing to determine if placement is appropriate. And that appropriateness is determined by assessing whether or not placement will ensure the defendant's appearance in court when required, will reasonably mitigate the risk of flight, or reasonably ensure protection of public. Those considerations involve the nature of the violations of conditions pursuant to 7559, the nature and circumstances of the underlying offense, prior convictions, basically their whole criminal record, mental health needs as well, any undue burden or risk to third parties or risk to public safety through placement in the program, and any other factors deemed appropriate by the court. So what are those supervision levels? There's DOC's telephonic monitoring system, which is sort of automated phone calls to remind people of court dates and things like that. Telephone meetings with a pretrial supervision officer, so an actual conversation can occur. An actual in-person meeting with their officer. Electronic monitoring, so that is probably the most, has the most imposition on these individuals. And then any other means of contact deemed appropriate. So potentially like Zoom meetings or on Teams, some sort of virtual interface or combination of the other factors. Compliance and review. So there are two different levels of compliance. One with the court-ordered conditions and one with DOC-imposed administrative conditions, like keeping your electronic monitoring device charged. So for instance, pretrial supervision officers must notify a prosecutor and use their best efforts basically to notify the defendant of any violations of court-imposed program conditions. So that is an obligation without discretion that the pretrial supervision officer has. If there are those violations of those court-ordered conditions, they have to report them to the prosecutor. They have discretion, though, to notify the prosecutor of DOC-imposed restrictions or conditions. And then the parties of the court may move for the court to review the defendant's pretrial supervision conditions at any point. For instance, if the defendant has met and been really compliant with them, potentially defense could move to have the conditions drop down a degree if possible, or if they haven't been compliant, there could be a reassessment of the conditions imposed altogether. The prosecutor may file the pretrial supervision officer's sworn affidavit with the court for an arrest warrant if the defendant has failed to report to the supervision officer, commits multiple violations of supervision requirements, or has absconded, which is defined in the statute. So fled the jurisdiction amongst other conduct. It should be noted that doing anything with those reported violations is up to the discretion of the prosecutor. They're not required to do anything with them. And as I understand, that might be something that CSG has suggestions with. But some context is, there was a lot of discussion about prosecutorial discretion in Act 180 as a whole, and also this. And I think there was a policy choice here made to give the prosecutors to retain full discretion over how to handle these violations. And then finally, there were policies and procedures and support provisions set up. By November of last year, DOC did establish written policies for the program so that the department could use it, any contractors could use them, and then also to assist the courts in understanding the program itself. They had to develop policies and procedures concerning what those evidence-based criteria would be for the various supervision levels that they established and what appropriate contact levels would be within those supervision levels. And then they have the ability to contract with a public entity or nonprofit, just a public entity that meets its criteria to assist in operating the program if they don't want to do it themselves and have the resources to outsource that management. And ultimately, the program is contingent on funding for it to operate. So essentially you don't have judges in counties ordering this program when it's not supported in that program. So right now, because of the appropriations for Orleans and Essex, they're really the only two counties where this is, where this program has been stood up so far. Any questions?
Just in terms of enforcement of the violations, is the idea just that we have another potential violation conditions release? So I saw that you could get an arrest warrant, but there's nothing further after that.
Yeah, and I think that is largely to give the prosecutor the discretion that they could either do another review under 7554, they could go forward with a sanction under 7559, or something else that might be at their disposal.
This didn't envision a penalty in and of itself.
Correct.
Because prior to this being in place, when a person went through an arraignment prior to any sentencing, they would be released to the community. And there was no supervision in the community of the person. There were conditions that the court set. But really the only supervision was your local law enforcement if they knew some of those conditions. So this is a layer to address public safety in terms of the person's released from court with conditions. It's now DOC that could do some supervision in the community. And depending on if there were violations of conditions of release, depending on the person's situation, it could be a very high level supervision, which could be a phone call. Or if it escalates, then the supervision becomes more intense to electronic monitoring, and it could go into home detention.
Which is technically a separate condition of release under this, and adjacent was amended at the same time that this program was created, because previously home detention was only available for those who could not make bail and were in a correctional facility for at least 7 days. That still exists, but it was also expanded to treat people that could also be considered essentially a danger to the community. And so it was sort of this middle ground between release into the community and incarceration.
Just two quick questions. Is it presumed that folks in this program would have already been in the system or not?
Well, so yes, they would have to be charged with a crime.
Right. So I guess I'm wondering if it could be someone's first crime or first.
I think that's a court decision, but they would still have to meet that minimum criteria or minimum eligibility, which would be 5 dockets against them, or they've already violated. Okay. So technically, if it was, it's likely that they probably already had law enforcement encounters, but theoretically, if it's their first run-in with law enforcement and they have 5 dockets against them, they could be eligible for this program. Okay. It's possible, but probably not likely that they didn't have prior involvement.
Okay, so that kind of answers my second question. Okay, thank you.
Questions? Thank you, Ben.
Sure.
Oh. Council of State Governments, we have a couple of folks here who have been partners with us for many years. I'm going on almost 20, I hate to say, but almost 20. We really started.
2007.
Yeah. Did you get the first justice?
Not us specifically.
Council of State Governments and the Justice Center. You did Justice Reinvestment 1 and then came back and helped us with Justice Reinvestment 2. And now you're helping us for the remainder of this year with overview and recommendations on the pretrial supervision. So I'll turn it over to both of you folks and let you both introduce yourselves for the record.
Sure. I'll go first because you're going to do most of the talking. My name is Ellen Whelan-Wiest. I'm a Deputy Division Director with the Justice Center. I live in Vermont, so it's always really nice to just drive over for work meetings. And was part of Justice Reinvestment 2 going back to 2019, and then have always been really happy to avail myself or to be part of anything that Vermont is working on that's related to criminal justice or corrections. And this is my colleague, David, who's been here for longer.
Hi, folks. Excuse me. My name is David Demore, and I'm a senior advisor with the Council of State Governments Justice Center. I've actually been working with Vermont in this capacity, over a decade, starting out with statewide recidivism reduction back in 2014, 2015, worked with Vermont on domestic violence programming and policy, and also on the justice reinvestment. And many, many years ago, worked with Vermont on some sexual offender programming kinds of issues, going back to the late 1990s or so. So I've had the opportunity to spend a lot of time with folks here in Vermont over time. Some of you I know well, some of you I've not met before. We're going to talk about pretrial supervision today in Vermont. I'm going to go through a few slides or skip a few slides because Ben did a much better job than I could possibly do explaining some of those slides, but they're in there for context along with what I'm going to talk about. And I'm going to talk a little bit about what we've been able to do so far, the interruption to what we've been able to do so far, the resumption of what we are doing, and what we plan to do between now and the end of the year to hopefully provide some support to Vermont around these issues and looking at pretrial. The presentation itself will do a brief piece on background, again, skipping over many of the specific slides about the legislation. We'll talk about initial findings, initial recommendations, and again, I want to say initial recommendations. We know where it needs to end up. We have to figure out with folks over the next several months, when can those things get there? How can they get there? And who needs to be involved to get there? And so we don't sort of come in and say, this is what you do tomorrow. What we come in and say is, if you want a really workable pretrial program that is statewide, you're going to have to get to a certain point. Then we have to work out the details with all of the people, some of whom we've spoken with, many of whom we still have to speak with, which gives me a moment to sort of say, we started this work, and I was up here with some other colleagues of ours back in early this year, February, March of this year. As many of you know, there have been some interesting moves at the federal level over the course of the last several months. One of those was that the funding for that work was overnight taken away in the middle of April, which caused us to have to cease work on basically every project related to that funding that we were doing. Over the course of the next month, month and a half, other funding sources kicked in and allowed us to resume some of the work that we were doing. And one of the pieces of work that we were able to resume is our work with Vermont. And so we came back. I can't get rid of this. We came back and started the work again, and we will be continuing that work through the end of this year to look at this piece, potentially longer than that, as we talk with funders about future work in Vermont and in other states. For those of you that don't know the Council of State Governments Justice Center, and let me get rid of this little picture that is in my way just a moment. I apologize. There we go. I apologize for those of you that do know, but for those of you that don't, we're a national nonprofit, nonpartisan organization. We combine the power of a membership association serving state officials in all three branches of government with policy and research expertise to develop strategies that increase public safety and strengthen communities. We are part of the larger Council of State Governments. The Justice Center is an arm of CSG. We do not operate based on the dues that states pay to CSG. That's CSG proper, if you will, or CSG prime, as we like to call them. The Justice Center works on the various funding sources that we have to provide the different kinds of programs and research that we do. The way that we work is that we bring folks together. We don't just come in and say, here's what you do. We drive the criminal justice field forward with research. We have a whole research division focusing on these areas. We work to build momentum for policy change with states, and in each state, that's different, right? What can happen in one state can't happen in another. We provide expert assistance in terms of our work. And one of the things that I realized that neither one of us really mentioned are our backgrounds. I have been with the Council of State Governments for 15 years. Prior to that, I worked in the field for 35 years, pretty much at the intersection of criminal justice and behavioral health. I'm a clinician by training. My work has involved work with violent offenders, sexual violence, domestic violence, a lot of work with risk and need assessment, a lot of work with folks that are incarcerated. I worked for several years in our maximum security facility in the mental health unit there, working with folks. So long time, both inside and outside, if you will, during the course of my career. And do you want to talk a little bit about?
Sure. I've been with the Justice Center for 12 years, primarily working on justice reinvestment projects across the country. Prior to that, I had worked mostly in government, in North Carolina, in New York State, in Illinois. So I'm thrilled to have been able to bring some of that to the criminal justice space.
And we tell you all of that just to say we've been around a while and we've been doing a lot of things over the course of our careers. Our goals are to break the cycle of incarceration, and pretrial intervention is one way to do that, and an important way. Really want to advance health, opportunity, and equity. And the goal here is public safety, right? You can't have good public safety without fixing the problem, and you can't fix the problem without fixing the issues that relate to the people behaving badly. And so you need to look at those things in a variety of ways, both in terms of accountability, but also in terms of what is necessary to have that behavior change. Why is my machine all of a sudden not wanting to change? Let's go down here and try that. There we go. So we've been involved in Vermont for a very long time. Again, in 2007, your first round of justice reinvestment. At that time, you had a rising prison population and really looking at identifying reentry and supervision options designed to reduce correction spending, which was growing at the time, and as always, to increase public safety. And then in 19, justice reinvestment part 2, if you will, once again, focusing on reducing high rates of revocation, or I should say in this case, focusing on reducing high rates of revocation among people leaving prison. If you have a lot of people going back from supervision, something's not working. And some of that, of course, relates to the behavior of the individuals. But if our goal is to habilitate, to change behavior, then there's something not working in what we're doing if we have to keep returning people at a high rate. And that was recognized. And so Vermont wanted to look at that and figure out how can we improve what we do? How can we make things better? Really strengthening access to, among other things, behavioral health resources and improving data tracking and reporting. Vermont, like many states, has a very large population of people with mental health and substance use disorder issues that are essentially stuck in the criminal justice system because they have not been able to access other kinds of services and programming. That's not everybody, to be clear. There are some people in Vermont that are in prison who fundamentally are very bad people. We're not making believe. But what we know based on the data is that there are a lot of people that there are other issues that are putting them there, as opposed to just bad behavior per se. There are things that have to be resolved that just saying, I'm going to hold you accountable by itself will not get us there. That's part of the answer, but not the only answer. And then in 2020, really looking at the issue of violent crime in Vermont and a number of other states, really focusing understanding on the scale and impact of domestic violence. This may surprise you. Your jumps in violence in Vermont are overwhelmingly related to your increase in domestic violence in Vermont. All right, so it's not the increase in gangs. I'm not saying that there's none of that. I'm saying that that's not where your biggest numbers are coming from. And we had a whole project with y'all a couple of years ago looking at this, and we were as surprised as anybody, just to be clear, when we started looking at this. And when we talk about domestic violence, we're particularly talking about interpersonal violence, meaning adult on adult, but also there's the issue of juvenile. And we could have a whole discussion for the rest of the day on that issue. We will not. That's not why we're here. But I do want to make that point, because later I'm going to talk about domestic violence offenders and pretrial supervision and why that's important. Pretrial supervision program was explained to you very well by Ben, so we can all ignore this slide for the moment.
Just one thing to point out on this slide actually is that, and this comes from Al and folks at DOC, that as of 2 days ago, the pretrial detainee population was 560 people. So people who are detained in Vermont state prisons awaiting trial, which is 100 people more than the same day a year before. And actually, I was looking at slides from 2019, and the detainee population was lower in the 400s back then, but had been climbing. So just to underscore that this population of people are increasingly taking up more prison bed spaces, which is just an important issue that the state pays for and has to be considering from a budget standpoint as well.
Thank you. Yes. And because of that, DOC said, would you come and take a look and see what it is that's going on, what we're doing, how it's working, et cetera. And this was just looking obviously at the pilot project. One of the reasons that was asked was that there's been understandably a desire to move this statewide. I'm going to, as those of you who know me already know, this subtlety is not my strong suit. You're in no way ready to move this statewide. It will be a disaster if you try to move this statewide right now. You need to do some other things in order to get this statewide. Over and above the issue of there has to be the funding to do it, there are some program tweaks that need to happen in order to move it statewide. And I very much hope that you will move it statewide, because I think this is a brilliant move on your part in terms of what you're dealing with, and really applaud you for that. Our goal is to say, here are some things you can do to make sure it works, so that the money that you put into it, that what you put into it to move it forward will in fact be successful, both for your all expenses and what you're doing, the resources, but also for the people that will be involved. Again, the eligibility is currently set in statute. We'll come back and talk a bit about that. The referrals come from the courts, as you know, and once again, ordered by the court. And the supervision is determined by risk and need assessments. DOC does that, does that risk and need assessment. They use the ORAS, or Ohio Risk Assessment Suite, because there are multiple tools within it that can be used at different times. I'm going to talk a little bit about this issue of risk for those folks who may not be involved in the criminal justice system day in and day out. Most people, when they hear the word risk, hear the word dangerousness. Risk does not have anything to do with dangerousness.
In this context.
If you want to know something about dangerousness, then I will do a dangerousness assessment. It is a separate assessment from doing a general risk and need assessment. And that's important, because when people hear high risk, they think that what they're hearing is high dangerousness. That is not the case. What high risk simply means is that that person is more likely to be re-involved in the criminal justice system through a new criminal act than the person standing next to him or her. So the higher your risk, the more likely you fall into a group that is going to be re-involved in the criminal justice system. And I use the word re-involved because when we do a risk and need assessment, somebody has to have committed a crime. I can't do one on any of us. Assuming none of us have committed a crime, I can't do one on any of us. We have to have committed a crime first in order for that assessment to occur. What that assessment looks at are what are called criminogenic factors. Criminogenic factors are things that are related to higher risk to reoffend, the likelihood of coming back into the system. And there are 7 or 8 of them that we commonly see. We're not going to go through all of them, but there are 7 or 8 that we can look at. And almost all risk and need tools look at those items. They look at them a little bit differently, but they all look at them. What we know is that when someone has high criminogenic risk, meaning more of those factors, that makes them more likely to come back into the system. If they have low criminogenic risk, it makes them less likely to come back into the system. Now, I do want to make one point here. Sometimes people might be very low criminogenic risk, but still have a significant number of mental health or co-occurring disorder needs. And one of the problems when that occurs is that those needs can indirectly bring them back into the system, not because of the criminal thinking, but because of the failure for the appropriate interventions in terms of their mental health or substance use or combined needs that they have. And responsivity is simply a long way of saying we've got to meet people where they're at. We need to be able to tailor what we do so that it works. For example, some of you are listening to what I'm saying, and that's how you're processing. Some of you are really not listening to what I'm saying, and you're reading what's up there, and that's how you process. Some of you do really well if we went and practiced it. We're not going to do that, so it's going to be a bad day for you. But for most of you, one or the other will work, right? And so there's different ways that we get to these things, that we do this work with individuals. We want to focus the resources to people that are higher risk so that those folks get a higher intensity of intervention. And that's important when we come back to the issue of talking about dockets and talking about who gets what and how. In terms of the supervision to clients and notifications, again, Ben went through this, but it starts with monitoring through the telephone reporting supervision program, right? And goes all the way up to the telephone reporting system, and a call from their assigned PPO per week, and one required in-person office visit per month. Now, this is because of resources. So, because I'm going to say something kind of strong in a minute, but before I say that, I want to say it's because of the resources. It's what people can do given what's available. It's inadequate for those people that are the problems that you're seeing with multiple dockets and multiple involvements with court. Traditionally, from what I saw, and I interviewed a few of them, typically people with additional mental health and substance use issues, that level of intervention, P3, is not enough for them. Now, to be clear, this is not, I'm not faulting DOC. They don't have the resources to provide what needs to happen for those individuals, but they need much more involvement, right? They need weekly, maybe twice weekly, maybe thrice weekly involvement. They need involvement in the field, not just in the office. And they need shepherding to programming. Maybe they need a ride there. Maybe there needs to be a phone call that says, have you gotten there? There needs to be a relationship between the people providing the programming and the officer, the pretrial supervision officer, who is overseeing that situation in that case. There needs to be a greater intensity and involvement. And so the long-term goal is to really move there. You can't do that tonight. You can't do that next week. You may not be able to do it this year. The long-term goal is to really think about how do we get there over the course of 1, 2, 3, 4, even 5 years. If you want a good pretrial program, why is a good pretrial program important? 2 reasons. You've heard the pretrial population in the prison is growing. That's not good. It's expensive. The other reason is that the more that you can be successful there, the less you'll clog the system. And your system's pretty clogged right now. And so the more that you can be successful at that front end level, the less clogged that system will be. And the people that are really scared can get the attention that they need, because there are some people that need that attention in the system over a period of time. But when you don't have time to do this much, it's a problem. If we get it down to this much by effectively responding at the front end, we can be better in terms of public safety with these folks that are pretty dangerous. And it doesn't matter whether they were incarcerated or not, they get out at a certain point. So again, we need to be better with them and have the time and the resources there.
David,
So what we're, sorry.
I'm just interrupting back to P1, 2, and 3.
You certainly can.
So in terms of the high risk, the P3s, they would have the telephone reporting. And then they'd also have one call from their assigned probation officer and one required in-person office visit. You were saying that that would not be sufficient enough for a person who also has behavioral health issues.
Yes,
If they don't have behavioral health issues and it's pure criminogenic thinking,
not sufficient for that either.
that's not sufficient either.
2 different reasons.
Okay?
The high criminogenic guy, I'm going to use guys, forgive me, but since the vast majority of it, right? The high criminogenic guy is going to look for any way to slip through that he can,
Yeah.
right? And if you're not paying attention, he's going to drive a Mack truck through it, okay? The behavioral health person, I don't want to say this, I don't mean this intellectually, but when I say they lack the capacity, what I mean is that their mental health or substance use issues are so strong that the idea that willpower alone will power them through, and as long as Joe checks in with them once a month, it's going to be fine, is just not true. I mean, the evidence is pretty clear about that. So in both cases, you need a greater intensity of involvement, not necessarily exactly the same, but this level will not work for either the person who knows he can get it over on everybody or the person who frankly can't figure out if it's time to go to bed or not. All right. And again, I'm using extremes to make the point.
Right. So you're saying what's limiting is financial resources.
Yes. I mean, they don't have the bodies, right, to do this. And
Maybe they shouldn't be the people doing it.
well, that's another discussion, but I'm not here for that. That's a discussion for you all.
Well, I said that maybe they shouldn't be the people doing that. I'm talking about the people with mental health or substance use challenges. It doesn't seem necessarily that DOC, that should be incumbent upon DOC to necessarily.
I'm going to get to
develop a whole
that.
system.
I'm going to get to that.
You're going to
Okay.
get to that.
That's what I meant.
Oh, yeah.
Maybe they should.
Yes, absolutely. No, I thought you were going down a direction of a different
No,
legal
no,
system.
no.
So hang on, David, we have more questions.
We'll get to that, I assure you.
That's a good question. I was gonna ask the same thing about how that an analysis is done. But then I'm also looking at the state's attorney who's responsible for deciding if a charge of violation of conditions of release should be made. But also it might fall into the need for some type of counseling that's missing. So how are, I really like our state's attorneys. And folks who work in this area, but it seems to me there's a significant amount of training that we could have in place rather than a constant input of resources. A certain amount of training in place for state's attorneys and members of DOC who can do some of the risk-based analysis to mitigate the problems going forward.
So a couple of things. I'm actually going to come to the issue of state's attorneys. Nothing bad about them, but the issue of how the process works in a little while. The DOC is very good at doing the risk and needs assessment and also at looking at the issue of mental health and substance use needs. Where it falls down is getting people to the appropriate programming.
Yes.
Right. So it's
We don't have.
yeah, it's not the issue of not identifying them. And then we get into potential, philosophical or ideological conversations about direction, et cetera. But let me just go with this. These are folks who, for whatever their reason, are involved in the criminal justice system. They have done something for whatever reason that has brought them to the attention of the authorities. What happens too often is that DOCs or courts, and I say DOCs, I'm thinking of community supervision in particular, it gets all put totally on their shoulders. And that's a mistake, and I'm going to come to that as well in this discussion, because it would be like me asking the clinician to be a good community probation officer. He or she isn't going to be good at it. And the reverse is true. That doesn't mean that you don't have well-trained officers, supervisors who understand their mental health clients or their substance use clients, but they're not the providers. They're not the treaters. They have to work in conjunction with the treaters to do that. And generally, most places that I go, not all, most places that I go, the supervisors are quite willing to do that, including in Vermont. Sometimes the bigger challenge, to be very honest, is getting the providers to be involved with that population and to connect with DOC. And I'll touch on that just a little bit as well as we move forward. And to be clear, all of these issues are system issues. None of these are blaming a person.
So, no, thank you for that. I unfortunately need to leave. This is.
I have that effect on many people.
We're having a conversation, and no, you're not having that effect at all, just the opposite. So thank you. I'll keep going through this.
You're very welcome. Please feel free.
I can go back to you too.
Both of our emails are at the end of the presentation. Feel free to reach out anytime. Happy to arrange a Zoom conversation, whatever works for you.
Thank you.
Thank you, Sam. So I'll discuss some of the initial findings. As is always the case, what's happening on the ground isn't as neat as what's written, right, up there, because we do the best we can with what it is that we have. So what we did is we did look at current operations in the pilot counties with an emphasis on availability of services and coordination across agencies. We met with key stakeholders, including judicial leaders, law enforcement, DOC supervision staff and leaders, and community-based service providers. Some of that was in person, some of that was through Zoom and remotely. We also looked at the current policies and procedures, including Act 138, and other relevant statutes and other guiding policies. We certainly found important strengths, and I don't, one of our jobs sometimes that's difficult is it's our job to find where the holes are, but it's also important to talk about where the strengths are, right? And what it is that folks are really doing well. And we saw a number of strengths and a number of impediments. The strengths that we saw included really strong partner commitment to success, strong supervision staff and foundational training and approach. There's a strong commitment to the pretrial work among the judicial leaders and good coordination between DOC and court staff. DOC continues to hire, train, and retain strong supervision staff who follow evidence-based practices. For those who are not involved in criminal justice routinely, there are a set of practices, sometimes called correctional interventions, that the research shows if you do that, you are more effective in reducing recidivism. And you should be doing that as a supervisor. You should be doing that when you're intervening, even clinically, along with whatever your clinical program might be. And Vermont DOC has had a strong interest, certainly the last decade I've been involved, with having evidence-based practices and how they work with their clients. And in the pilot county that we visited, key stakeholders were very informed and engaged in the success. And in fact, there were a number of things that were getting in the way of how they were doing the work in terms of the sheriff and the police department, not getting in the way because of the departments, but because of the way it had been structured. And they got together and figured it out and came up with a way to solve the problem, which is exactly the kind of thing that we look for, right? When we talk about strengths or coordination between groups.
So when you say key stakeholders, do you also mean other community providers? Or you
Yes.
just mean folks in the law enforcement and judicial
No,
system?
other community providers as well.
So you spoke with Northeast Kingdom Human Services?
Yes.
Okay.
Okay, so despite that, there's a few challenges. One is that the processes it's structured right now in terms of referral and the reporting processes aren't conducive to effective supervision practices. The referral process is kind of difficult. I would argue that if you have 560-ish, was it, people that are incarcerated for pretrial, you've got at least 200 too many, at least. And that 200 too many is because something's not available, something not happening, right? And even where we were looking in terms of the pilot projects, the hoops that it took to get somebody to that programming and to be appropriate for that programming were too great. It should actually be the opposite, I would argue. It should be assumed that if it's pretrial, you're appropriate, and then you determine whether they're not, as opposed to determine 12 steps and then finally, right? Because now we're and I'm being a little silly, but now we're 2 months into the process and not being that silly, right? And there's so much room for that individual to basically go down the wrong road during that time. Secondly, there needs to be a wider range of who's acceptable in terms of the programming, but that can only happen if the P3 is more intensive, right? If the P3 isn't more intensive, you can't do that. Which leads us to the second challenge, which is that the current DOC staffing doesn't allow for the intensity that I'm talking about. They just can't do it. And then thirdly, coordination across state agencies that serve this population must be stronger to provide the necessary services and treatments. And Representative Emmons is probably going to laugh at me now, but I've been yelling about this for a decade. I mean, really, everything's under one roof and people can't figure out how to get it together. It has to be together, right? It's nice that, I mean, frankly, most states would kill to have that kind of stuff under one roof. And yet, despite lots of work and intent and hard work on the part of different departments, to be clear, that's not happened. There has to be a stronger demand that it occur as opposed to go and see if you can figure it out. It has to happen because the people that we're seeing that are failing again and again in the criminal justice system are people that are people with co-occurring disorders, people with mental health and substance use. Ironically, when we talk about sexual offenders, which we don't want to talk about, but when we do, their recidivism rate is massively low, right? But the high recidivism rates we're seeing are the people that we don't pay enough attention to, right? Which is the people that have those significant co-occurring mental health and substance use disorders.
But
So the
David,
challenge is, oh, sorry.
when you say it's all under one roof, you're saying because all those departments,
Are under AHS.
Corrections, Department of Mental Health, Department of Children and Families, Department of Health, all of that is under the Agency of Human Services, and they ought to be coordinating.
Yes. And to be clear, different agencies have been trying to do that. DOC certainly has been working at that, and there has been some movement between some of the agencies. It's not enough. It needs to be more. There needs to be a lot more streamlining, if you will. So let me just mention those two challenges a little bit more. Right now, DOC doesn't have the authority to effectively and immediately respond to violations of conditions of release or to work collaboratively with the courts under current procedures. In other words, they have to go to the state's attorney. This is not a dump on the state's attorney. I want to be clear. That's not the point here. The point is there has to be swift, if you forgive the old statement, there has to be swift and certain responses, not because I want more people violated. I'm going to argue people are failing because there isn't that certainty. And so people are just sort of skedaddling about and they're well, I got away with this one. Well, this has happened. Well, yeah, Joe turned this in, but nothing happened. Well, so what's happening is that unintentionally, people are getting a message that it's just babysitting. And that's not what you want. You want improved community safety. You want improved outcomes for that individual. And so there needs to be the ability to respond and to talk to the court. I was talking with Judge Tipo, and I said, look, Judge, are you telling me that the officer can't come to you and say, Jack is having this problem and we don't want to violate him, but could we have a conversation with him over lunch maybe? Can we just stop in for 5 minutes? And no, that doesn't happen. Well, that should happen. That kind of connection should be available. It shouldn't have to go through the third party. Not that, and when I say third party, I don't mean that negatively. I don't mean to cut the state's attorney out of it. There's a point when, especially with a new crime or whatever, they have to be involved. But there are so many things that could simply be the judge saying, hey, Jack, come on. If you don't do this, then this is what's going to happen. And so I want to see you in 2 weeks to make sure it's going okay. Or the officer will talk to me in 2 weeks to make sure it's going okay, because maybe the judge is too busy to be fair. And so maybe he just asks that Jack, the officer, connects with him in 2 weeks through an email and says, things are going well with Joe. Yes.
Do courts administer this kind of program in other states?
In pretrial programs?
Or, yeah, it seems.
With the exception of perhaps 1 or 2 other states, it's always administered under the judicial system, pretrial.
Okay, because that seems like it
I
might.
think you need to be clear on what David just said. Yes, it's in other states, but it's administered through the courts.
Right,
This is not administered
Through the courts.
This is through DOC.
yeah, well, that's my
my-
concern.
So it's really
Is
different.
it might.
So a
It
couple-
also means the courts have their own supervision.
They have their own
Staff work
folks.
for the courts.
Right, no,
Right.
I understand, yeah, no, I understand the implications of the question and the conversation, but we need more staff no matter what we're gonna do. And I know the courts don't do that now, but it could be something that we talk about. I don't know if we've talked about that.
So we did talk about
Yeah,
where
there
it
is.
should,
Yeah.
where it should lie. And the only option we really had that was reasonable and available was the DOC.
Because
I-
courts don't
'cause
have
we
any
did-
security.
Well,
supervision.
Right.
You don't have court folks doing any supervision out there now.
but maybe that's the problem.
I think part of the conversation that occurred during that time too was given the current structures of our institution. So for
Yeah.
instance, Vermont has a unified DOC system, relatively speaking. Vermont, but for instance, with Vermont, like when you look at these pretrial supervision programs that are run, like we looked at Illinois, Illinois has a county-based system, so their own county judiciary systems run this. It was a question of sort of resources and being able to develop the skill to do that. And I think the policy decision was it wasn't feasible without a wholesale reformation of the judicial system.
Because we also don't have a county system.
Right, and we could actually build off of the DOC locations. And yes, you're right, if we had the best of all worlds and all the resources and time, we would have, and a willing partner as well, which court wasn't really in that position. DOC was very much a willing partner. So that's multiple reasons why we ended up here.
And to be clear, the other states that are, even though there's not a lot of them, the other states that do have it in the same way have been able to do it effectively. So it's not an undoable thing. It has more to do with how things were structured and developed in different states. I work in a unified system in Connecticut, but our probation isn't under DOC, it's under the courts. So when they did this, they were adding on to what was already in existence, much like you're doing here. It's just that it was under a different umbrella, if you will. And our parole is under our DOC. So even though we're unified, it's a little different.
Illinois also has county-based probation. So it makes sense that they would have to. But yeah, it's different everywhere. And I think what David's going to walk through are, back to the beginning, we try to tailor everything we recommend to the reality and what has the most potential to have impact. So there are some tweaks that could make this all work really well, even within the system that exists now.
And to be clear, currently officers, when they're supervising people post-conviction, have that ability to chat with the judge, to talk about different things, to do that. So we're not talking about something that is atypical or unusual. That I would actually argue the fact that it's not is what is unusual. Okay.
Okay.
Secondly, the second challenge.
Question here, Dave.
Oh, I'm sorry.
I thought you had answered it when you had talked about the other states, their courts administering probation, but when you just said that in Vermont, after they're put on probation, probation officers have the ability to talk to the judge and they do that regularly. Where?
By where? What I mean.
Where in Vermont?
Where in Vermont? Where, is there anywhere you are not allowed to?
We're allowed to file violations directly with the court. I think that's the root of it. We
Yeah,
can
that's-
contact the court directly for anything going on with the patient, whereas for this program, we can't.
So
So it's
in
fine.
Bennington, probation officers don't go up and check.
Oh, I'm sorry. I didn't,
Filed a
I
violation.
apologize. I didn't mean to infer it that way. Yes.
Well, that's what you would.
I can see what you're saying,
They
yeah.
go and they talk to the judge and say, we get the guy in, every 2 weeks with the judge, but
No.
that connection with the probation
That's
officer
not
when
what
the judge is saying, happen.
Now, arguably, in treatment courts, that's exactly how.
Well, treatment court is
Yeah.
different.
And what we're really talking about here is something more similar to that than to the traditional method, if you will. Not suggesting a treatment court, just clear. But my point is, it happens, right? It's done. And so it's not like, gee, nobody does this at all anywhere. Yeah.
Could you just identify yourself for the record?
Yeah, yes,
And
Gary
also to speak up, because this mic doesn't always pick up folks who are talking on the side.
Gary Marble, Deputy Director of Field Services. We also have court liaisons in the offices where we have the staff resources to have one. So somebody, an officer just sits with the court, and the court will reach out to get clarifying questions about supervision and about specific cases for that. And that can be a direct line of communication as well. But there's a formal mechanism with probation, and that can initiate the conversation through either a request for a modification of conditions or a violation. Whereas in this place, there is no formal mechanism without going through the state's attorneys.
So the issue here is that the request could be where the officer that's doing the supervision could file directly with the court and not have to go through the state's attorney.
Yes.
Because now it's going through the state's attorney, and it's up to the discretion of the state's attorney whether or not to pursue it.
Correct.
Because it's a may of the state's attorney.
And what's happening in some cases is that they're just not going anywhere. And to be fair, everybody's overloaded. Again, this is not an insult to anybody. But you don't have that immediate response. You don't have that, well, wait a minute, if I don't do this, then that's a problem. And so, and I'm thinking in particular of one young man that I spoke with who has a lifetime of mental health issues, has a lifetime of substance use issues. He's 31 now, I think. He was proud because he was clean for 6 weeks. I doubt that he's been clean from the time that I saw him to now. I don't mean that as an insult, but looking at the pattern of his life over what was going on and the fact that the woman that he was involved with had been clean for 7 weeks. I said, so where are you going? Well, I'm not going anywhere. Are you seeing anybody? Well, no, I don't see anybody. I've been clean for 6 weeks. That sort of thing. And yet no ability to sort of move that person forward. And he wasn't a high criminogenic thinker person. You know, he was a very traumatized, long life, early life abuse, significant mental health, significant substance use issues that really needed a supportive pre-service program to help channel him into the places that he needed to be, as opposed to his umpteenth time back, you know, even if it was for 3 weeks or a month or 6 weeks, umpteenth time back in prison or in jail, if you will. Now, there are others that's a different story, and I never want to make believe that there aren't some people that are very dangerous, and we have to be very careful. But many of the people that we're seeing in the system are people that if we intervened in different ways than we've been doing, we can get them out of the system. And they're costing us a lot of money on top of everything else, right? Plus the nuisance crimes, right? The shoplifting for the drugs, the breaking and entering for the drugs, the whatever for the drugs. You know, they're doing all of those kinds of things that are going on that are making life unpleasant for other folks, you know, particularly in the more urban areas, and this is true across the country. It's hardly unique to Vermont in terms of how that goes. I live in an urban area, you know, see the same thing. I live in New Haven. I see the same thing happening there in terms of how that goes. And so it is something that we sort of want to pay attention to over time in terms of, you can't solve a problem if you don't identify it correctly, right? And so what we're talking about is you've got a multi-level problem, some of which is related to the good old criminal thinking crime stuff, some of which is related to these other things that, and in both cases, good pre-trial supervision, especially if you're going to have folks out anyway, right? A good pre-trial supervision is going to improve public safety and minimize the number of times they're coming back to the court, right? You've got 5, 6, 7, 10, 12 dockets. Talk about clogging up your courts that are trying to catch up with what's going on, especially because often the dockets may not end up together. Sometimes they do, sometimes they don't, right? The third one, and this is the big one, well, one of the big ones, there has to be more coordination, you know, again, till I'm blue in the face, across state agencies that address criminal justice, housing, mental health, substance use issues, to more immediately and consistently access the supports. Now, to be fair, we all know that there are some places where that's not available. It's that simple, and I understand that. Other places it is available, and it just depends on where we're talking about in the state. But what we've seen, I remember here a few years ago when I was assessing some of your hub and spoke stuff, which is really good, but still it was dependent on where it was and how people could get access to it in terms of their transportation, et cetera, et cetera. So that's a big one, some of which can be solved by a clear agency-wide plan in AHS that integrates the different programs to respond to criminal justice clients. So we have some initial recommendations. These are initial. We have a lot of work to do and a lot of people to talk to. This piece has to do with what the research tells us, bottom line. And what does the research tell us? It tells us that successful pretrial systems are supportive services. If they're focused only on supervision strategies, mandatory drug testing, electronic monitoring, reporting, they don't improve outcomes, bottom line. Supportive pretrial services use a combination of accountability and strengths-based counseling, addressing underlying challenges. They're far more successful at improving court appearances, which is one of the problems you're dealing with, and reducing rearrest, which is, of course, the other problem that you're dealing with. And in the discussions that I've had with the supervision officers, that the very few of them right now that are looking at this and focusing on it, they're there. I mean, that they're there. They want to do that. The capacity to do that with any reasonably sized caseload won't happen. So it's not an argument of, oh my God, we can't get DOC to do this. No, DOC will do it. In terms of choosing who those officers should be, not all officers are good at this, choosing what officers it should be, and making sure that the right training, to somebody's question earlier, the right training is available for those individuals. And particularly the supervisor and the officer that I spoke with, completely and totally on board with that, get it fully. That's a plus that you have. You don't have a fight to get the agency to agree that this is the way it should go. The second piece is the hub and spoke, and you have that, right? Pretrial services work better in both court and community presence. The court-based staff serve as the hub, interviewing and accepting folks into the programs, whether it's at bail hearings, first appearances, or whatever particular system, how it operates. They make the voluntary referrals to the quote spoke agencies, community organizations that provide the services, and they help people get there. I worked for 25 years, worked for 12 years in Indiana and then 25 years in Connecticut before I joined the Justice Center. And one of the things that happened for our severely mentally ill folks was that the officer, as the supervisor, myself as the treatment supervisor, would go jointly in the officer's car to help get that client to the right programming that we needed to have, whether it was our programming or somebody else's programming, because we oversaw a number of things. And we couldn't force, we couldn't force them. That's not the point. But the fact of the matter is the simple fact we showed up and we were there, and there was a ride, got them there. And we have a pretty good public transportation system that still did not work well enough for those folks with the greatest need. And the third component, of course, is that of evaluation and data. It needs to be measured. We need to be looking at that. If it doesn't decrease your prison population, if it doesn't help unclog the courts, then you need to rethink it again. But if it does those two things, the money that you'll save in those areas and the ability to focus on the scarier folks, if you will improve dramatically. And we've seen this happen. Johnson County in Kansas is an example of where we've seen this happen very well. In my state in Connecticut, I've seen this happen very well. Nothing's perfect. None of them are perfect, but we've been able to do that in terms of reducing. We've had a dramatic reduction in our prison beds, and we have not had that increase in the crime in the state that we've seen. Now, there's some ways to immediately strengthen things. One is increasing the frequency and intensity of contacts, including more in-person interactions. When I say immediately strengthen, what I mean is DOC would look at, here's what we've got, and given the number of people we have, what can we increase with this for this caseload? And they may not get to where we want to get at the end, but maybe it can go from 1 to 2, right? Or from 2 to 3, whatever that could be. Secondly, would argue that authorizing DOC staff to make direct referrals to the courts in response to condition violations would be an important component, not because I want them to be sending a bunch of people back to prison, but because I want the accountability up front. Because once Joe hears from Jack that if they don't do this, they are much more likely to say, I guess I better do it. I guess I better, really cooperate with folks that are doing this work with me. I'd like to provide additional opportunities for DOC staff to interact with the courts and to adjust conditions based on client progress. I'd like to direct DOC to add behavioral health and substance use screens to their initial assessment of each client to better and more immediately identify these needs. I need to make a quick point here. Many of these folks already are coming with a history. They don't need that screen. There are a few folks that do come in that don't have it. And you can do a very simple 10 question and 8 question screen that does not take long. That will just, if you've got a serious thing going on, it will flag it for people to be able to get a full assessment. Probably 90% of the people that come across DOC's desk with mental health or substance use issues are coming across with the history already available. So they don't need to do that. So I don't want to make it sound like, oh my goodness, everybody needs to get this, because that's not the case. Did I just? I did that. Direct relevant health and human service agencies to develop a streamlined method for referring PSP clients to behavioral health services, and focus the use and resources of PSP on those individuals who pose the greatest public safety threats. 5 dockets is not a measure of threat, it's a measure of annoyance. All right. And so who are the people that you should be worried about? And I don't mean you should ignore people with 5 dockets. That's not my point. My point is that you want to really focus on those people that are most likely to pose the greatest risk of doing harm to themselves or to others, including and particularly people with domestic violence related charges, especially those who have a DV charge with either a weapon or strangulation, both of which are strongly tied to death in the near future. And so you really want to focus on those people that provide the greatest threat to themselves or others, and that intervention can decrease that threat the most. And someone might say, well, those people will be in prison. No, many of them are not. They are absolutely not in prison. They are absolutely out walking among us, and intervention and response and supervision would be very helpful. And then the last one, of course, is collecting and monitoring data, which in fact DOC has been developing over the last few years and doing more and more of in really good ways. But we would want to make sure that it's focused specifically on this program as well. 2 quick examples. I mentioned Connecticut. Now we're talking an extreme. We're talking a budget of over $1.25 million a year. But the reality of it is that based on the prison bed cost in Connecticut, the program saves the state between $20 and $30 million yearly in bed costs in the prison. It's a 24/7, 365 operation. It looks at a lot of different things in a lot of different areas, and it has different supervision levels, from intensive, which includes RF or electronic monitoring kinds of things, and ongoing intervention and contact with the officer, moderate, and then indirect, which is either managed through the treatment providers and adult behavioral health services, sometimes also telephone kinds of contacts as well for the lowest level. All you're worried about with those folks is making sure they understand their court date is next Thursday and to get there in time, and you're not really worried about other issues.
Is that a statewide program?
That is a statewide program.
How many people do they serve
Um,
generally on your caseload?
That's a caseload or
Tell me how
total?
many people are they serving in this 1.3 million statewide in Connecticut?
I don't know the answer to that off the top of my head, but I can get it easily, and I'm happy to send it to the co-chair and make sure that you actually don't, I know it's in the hundreds, but I don't know what the exact number is.
Yeah, yeah.
But I'll find out.
I don't think that what we've appropriated so far is actually a low amount for the number of people that we're serving. I think it should be able to go further, I guess. Especially when I'm looking at numbers like that for the whole state of Connecticut with a much higher population.
Sure. But the difference that you have to understand, though, is that it's built into what is already the court system. So there are certain.
It's a whole different
built-in
system. I get
issues. Yeah.
that. I get that. Yeah.
In your case, it's going to cost a little bit more per head because of it crossing over from court to DOC. But given the way your system is currently structured, if you were to try to move it to the courts, the price tag would be overwhelming, nor do I think you would have the people available in the state to fill those positions. Jefferson County is another one here. This one is a little bit different. It's located in the detention facility, again, 24/7, 365. They do a detailed pretrial report, which includes the validated risk and need assessment, criminal history, behavioral health needs, et cetera. The management unit, though, so inside you've got the people doing the assessment to get people out, because there they go in, right? And then in the community, you have what you have here, which are the people that are going to do the management. In their case, it's located in the courthouse because it's a county system with county probation, not a statewide system that you have here. All right, key takeaways. If you want to make this statewide, as it's currently designed, you're not going to be able to provide the adequate supervision to make sure that there's the success. So you're going to need some tweaks and to really be thinking about the building resources over time. In the short and medium term, DOC needs authority over court referrals and more resources to hire pretrial services. When I say short and medium, that's 1 to 4 years, right? 1 to 3 years, whatever. We all know that all of us are in flux about budgets right now, and we understand that. So I don't want you to hear us saying, oh, you're going to be able to get this kind of money this year. I just want you to think about how do we parse this out over the course of 1, 2, 3, 4, 5 years as we think about these things. Stronger coordination between behavioral health, housing, and corrections actors and agencies are needed. And the initial adjustments and investments can help you avoid the continued growth of your pretrial population. I mean, you're hitting almost 600 now, right? So from 4 something a year ago, which was already an increase from a few years ago, which is now a greater increase in the last year, this is costing you money too. It might not seem that up front, but it is costing you money as well. Not to mention, it's not doing a lot in terms of the underlying crime and safety issues that everybody is appropriately concerned about. Over the next 5 months, we're going to look at a number of things. What are the ongoing coordination barriers between state agencies that make referrals to community programming most difficult or inefficient? How do members of the judiciary and the legal community, states, attorneys, defense, et cetera, experience or anticipate working with the program on a statewide level? What's the bare minimum for additional staffing that we needed to make sure the quality of supervision is where it should be? And how can eligibility criteria and supervision intensity and resources be most effectively focused on those who pose the greatest threat to public safety risk while they are awaiting trial? So we have a lot of people that we still need to talk to over the course of the rest of this year. Through September, we'll be continuing engagement, folks from the courts, judges, state's attorneys, defender general's office, community service providers, because we've only been focused in one small area. Draft report in October of the findings and recommendations for both administrative changes and legislative consideration, and then work with the department and with the legislature to identify viable changes to policy and statute and to assist them in drafting or implementation planning for those updates and improvements. And the key word here is viable. I mean, we understand that everything cannot be done at once and that there are multiple and competing issues, but at least we can help build the roadmap, right? And then look at what can we do now? what can we do in a year or 2 years or 3 years, or what do we think we can do? Because obviously from year to year, there's different challenges. At the very least, what we want to say is, if you do this, this is what you can expect. If you do this, this is what you can expect. If you do this, this is what you can expect. And by doing that, you can then also make some decisions about where you want to go with this. Do you want to move forward this way? Do you want to rethink what you want out of the program and change that dramatically, whether that is tweaking the way that I would like you to tweak it in terms of what I think makes sense based on what I've seen in other states? Or maybe it's, you know what, we can only do this in here, and that's what we can do. That's for you all to decide. But whatever that decision is, what we like to do is to give you the best information possible. So whatever decision it is, you're able to do it in the best way possible, right? In terms of outcomes and thinking about that. So whether it's just, do I just want to get people to court? Or it's, am I thinking about the community safety aspect of pretrial supervision? Or am I thinking about the incarceration costs? Whatever that is, there's different roads, but each road requires certain ways, certain things to think about in order to have them be successful. I have bored you long enough. If you have other questions, we are happy to answer, in addition to which at any time, as we mentioned to the senator, our information is at the end of this presentation. You can email us. We're also happy to talk with you over Zoom. We'll be up here. Well, we'll be up here all the time, but I'll be up here regularly, and we will be doing the things that I mentioned over the next several months and have a report back to you in probably November. You need it by, right? By November, that will have additional information that we've been able to suss out with our work. Anything you want to add on that? Anything that I said that you're mad at me about? Anything that I said that you're mad at me about? I usually make somebody mad almost every time.
I would have one.
Yeah.
In terms of the contacts for the level 3, those, I just want to be clear, those are the, so when we are able to, and we have the ability, or we do go above that. I know that our officer, our control officer, has had more contact than that when able. So I just wanted to make sure that was clear. We're never appropriately resourced, and we have the available time and staff. But we're happy to go to what level we need to or engage that person.
So I know that this is rolled out in Essex and Orleans, which are small counties. And I think if we compare the number of cases going before the courts are very small compared to other counties in the states. How many folks are actually going through this pretrial supervision program in those two counties?
Those numbers would be.
Well,
So, good afternoon, California Chief of Operations of Vermont PSC. Currently, there is nobody on pretrial supervision. Folks that we've had that have all been violated. We had upwards of around 8 or 9 at one point, but currently there's nobody on pretrial supervision. A lot of that, I think, is impacted by the backlog in the court and the requirement to go through the state's attorney. Both are very supportive of the program, very much engaged with our litigation control staff in the office, but
so between the two counties, there were only 8 folks, and then they ended up violating and are now incarcerated as a detainee.
I do not know if they were all incarcerated. They may have just been removed from Dublin.
Wow.
Yes, my question. Yeah, they're probably not all in jail.
Right.
Well, I think that I was going to ask what kind of data you were giving out on the pilot program with 8 people. I guess you can't track how this has affected public safety, the court backlog, or any of those things. Should we be moving to a different county that we can actually gather the information that a pilot's supposed to be providing?
So two, both excellent questions. The first one is that at the time, I think when we were there, there were 5 that were at that time on pretrial supervision.
This was in late March.
Late March. But to be clear, yeah, that's hardly a full representative sample. Our April plan before everything changed was to go to the major urban centers and to look at what was happening in those centers and to talk with those folks. because you're right. The issue of just the small counties is not enough to look at by itself. But to be very blunt, what became very clear was that if they tried to do what was already, from my perspective, as I've said, not working well, in a relatively well-resourced small place, once we get to the big place where you've got, for example, 3 different judges looking at different cases, et cetera, that would be really a real nightmare. So our plan was to, at that time, go to what we are now going to be doing over the next couple of months, which was to move to these larger places, try to get an understanding of what they were looking at in terms of volume, try to talk with in Burlington, where there are the 3 different judges, talk with those folks about how they're handling that, look at whether or not something should happen there where these types of cases were under one person. We've talked with Judge Zone about, what might need to happen, what kinds of tweaks could occur. So there's a lot of work we have to do to figure that out. It's why when I opened this up early, I said, you can't open this statewide based on this. There's too many other things to figure out, both in terms of the different needs in the other parts of the state, particularly the urban areas, and the construct of the program itself in terms of what is needed to be part of that program. So I would absolutely agree with you, and that's part of our plan over the next few months, is to do what we would have done in April and May had we not had the service interruption that we had for a period of time.
Yeah, and I guess just to follow up on that, so this seems to be focusing a little bit more on how we're going to make this work, but I'm as interested in understanding the benefits so that I can justify the costs, and I don't know what can be done with this pilot, what you're doing right now to help us justify the further investment in extending it statewide. So that I'm not asking for an answer right now, but if that's part of what you're looking into,
that would be part of. So what we want to end up with is, here's what you have in these different places. Here's the volume we've got inside. Here's how they're getting there and what's going on. Here's what is or isn't happening in those different places. Here's what it's costing you, which we don't have right now, but here's what it's costing you to do that. Here's tentatively or generally, here's what it would cost you to do this other thing. Here's where the difference is in your cost, meaning why would it be worthwhile or beneficial? And then we can show you some outcomes from other states in terms of what works there and what that's done in more detail. And there's no reason to say that if it works in state A, it won't work here. How you get there may be different, right? But you can get there. And what the main thing that we see, I'm trying to think of how to say this the best way possible. The main thing that we see that these programs benefit when they're done well is that it keeps the people who end up being trapped in the system because the system was unable to respond early on enough. And by the time the system responds intensively, they're so deep into the system that the cost of the response over and above the beds is dramatic, right? Because we haven't even added in the cost of the continued court involvement, the cost of the continued prosecuting attorney involvement, the cost of law enforcement involvement. And so they sort of build on themselves. And the main goal of any good pretrial program is twofold. One, get people to court. And two, have the community be safe while they're out. And if possible, intervene in a way that some of them don't even need to go any further than that, right? They could not go further in the system at all. We can throw them out, so to speak. You're done. Some of them, it's simply diverting them from jail, which when you talk about diversion here is often what's meant, right? Keeping them from jail. Why do we want to keep them from jail? Again, 2 reasons. Number of beds. You still have some people out of state. So you've still got some people out of state. I would argue you want to use the beds for your most dangerous, not your most annoying, right? And not your most problematic in terms of mental health and substance use needs. Use the beds for them, get those people back. It's costing you a lot of money to send them out, get them back here. Don't overfill your beds and get as many people out of the system and being productive as you can. You don't have a large population. And the more people that you have that are not productive in your population, the less helpful that is. And so there's a lot of benefit to that from a cost benefit perspective, some of which we can show you, some of which we can't. right? I can't show you what the benefit would be of those people being employed, other than from a humanistic perspective. But we can certainly show you cost of the A versus B, right, for this number of people. And the simple fact that your numbers are creeping up, I'm not sure if creeping is even the right word, jumping up significantly means that there is some cost somewhere happening in terms of what's going on. So how do we look at that differently? How do we divert some of it? How do we make some of that cost less?
One follow-up comment. So I mean, I think what really was the focus on, in at least my committee on getting this through was the first 2 points that you made as far as getting the person to court and keeping the community safe and making, and those I think continue to be very important.
Absolutely.
As far as early intervention to keep this person from not being a repeat offender is certainly very important, but just wanted to make that comment.
Absolutely.
Lisa, did you have your hands up?
I guess, yeah, sort of, yes. I mean, one of the key things that I heard you say is that we should be thinking about more presuming that people would be eligible for the program and assessing them out as opposed to going through the multiple steps to, assess whether or not they should be in. I just found that that concept an interesting thing to be thinking about, because I think that's sort of ultimately like what we would like to see. I mean, I think that really is.
Can't do it overnight.
You can't do it overnight, granted, but I think that's only really one of the ways to really reduce those number of detainees is if we presume, it's like presuming competence for people with disabilities. Presume that somebody could be successful in this way, or at least mitigating the risk in the community, et cetera. And so I just, it was just a thought. And then the, budget side of me goes through like, what are we doing with $600,000?
That was a one-time, I just want to check with Trevor, that was a one-time, that 600,000, I don't think it's in the FY26
I believe it
budget.
is one time, right, Isaac?
I think it is.
Oh, base.
Base. I thought last year we determined it was base.
Yeah. But we do not allocated funding for the position, so that money covers the itself.
It's not targeted towards positions.
We didn't have any funding for the position, so we just, for salaries.
600,000 for salaries for this program.
Yeah.
In 2 counties, they had 8 people.
Right, I mean, I think it goes to Martin's question, which, we'll have further recommendations from you when you come back about, what, if anything, should we do about determining viability on a statewide basis, and whether we could shift pilot to a different, more urban county.
The one thing that you do have to keep in mind, though, is that this is true in all programs, there's a startup cost. Right, in terms of, you can't just, it's not just a matter of, oh, here's an officer that's going to do this, right?
Right.
There's an issue of what you're going to do structure, there's the issue of who's going to supervise that. There's the issue of what are you going to backfill that officer to do with the officer that was managing a different caseload. So I would just caution you against the difference between a startup and an ongoing cost in terms of that. And in terms of where I live, none of that existed because of where it was, what it was under, right? And so it was just a matter of 3 people, right? Because of what it was under and what was already in place. So I do want to caution you about the difference between cold startup costs versus building on something that was internally already there.
Right.
And there.
Part of the reason that I just heard previously say why we went with this in response to Wendy's question was like, because there was already some infrastructure in DOC and the probation and parole community-based system. So we weren't starting at zero.
No, but you weren't starting with the built-in. Our people were already in the courts day in and day out, all of them, every single one of them. And so it was just a matter, it was a tweak, not a backfilling of positions that had to happen because they didn't get new supervisors. they had the same.
Yeah, I
same person.
understand that it's different.
Now, if you're talking about for every two people, there's that cost, yeah, then I think there's some questioning that probably should be going on, but I don't think that is or should be the case.
So when we originally looked at this, there was at least $1 million price tag. Probably a little bit more than that, Isaac, if we opened it up statewide. And going through the budget process last session, we knew we weren't getting $1 million plus. So it got scaled to 600,000. And that's why we said, well, we can do it as a pilot. And the two counties that were picked, Essex and Orleans, was done purposely because we didn't want to overwhelm the system. And that's why those two counties were picked to see how it would work. That's why we didn't go towards like Windham County, Windsor County, Rutland County, where there was higher numbers, because we didn't want it to fail. And we didn't want it to go over the 600,000.
And
So that's why those two counties were picked.
which are perfectly reasonable. And to be clear, with a different referral structure, those numbers would be higher, even in those counties.
So if the referral was presumed that you would go there first,
You'd have a much higher number than what you have, as opposed to here, here, and then here.
Or if it's risk-based and not just 5 dockets or.
Yes.
right?
And I think you probably get good input from state's attorneys on that question, because I recall that the court and state's attorneys really, their input led to where we ended up.
Yeah,
Sure.
Yeah.
And I know, I mean, having had discussions with the dearly departed late Senator Sears, as always, it's like, how do we get something out there? Start figuring it out, see what happens, and then how do we tweak and build on it? And that's where you're at now. I mean, to be really clear, and you've got good bones, but now, or a good foundation. Now we need to figure out all of the different components to make it work. Because even if it did work perfectly in Orleans, I would argue, or Essex, I would argue that we still have to go to some of these other places to see how's it going to work there, because it's not going to transfer automatically one-to-one.
Every county's different. We
Every
find we have.
I have learned that over the years.
14 different state's attorneys.
Yes, that's why we have 14 separate justice
Sure.
systems.
I have honestly learned that in my time here.
So you'll have a report back to us sometime in November, December. And then for the committee, that would be some work that maybe we could make some recommendations in terms of changes to the statute or not. So we'll be looking forward to hearing back from you in a few months. It's not that far away.
It's gonna go fast.
Any other questions, comments?
I was just looking at the letter that we sent that
Last year?
last year, right? And it asked for DOC to present what the cost would be for a statewide program. And I didn't know if the committees of jurisdiction received that information, or doing this option with CSG as sort of needing to provide the background before moving to that step.
Didn't, not that I was aware of. I think this past session, I think what was happening, particularly in my committee, is there was such a new committee. It took a long time to bring everybody up to speed. So there was a lot of issues that we just didn't follow up on because we had to get through the basics in terms of what corrections is.
Representative Speck, I mean, we have presented cost estimates on this in the past multiple times. I think the main issue at play is the eligibility criteria. And if I remember correctly, consent shared a few years ago, Ben could fact check me. I remember the late Senator Sears saying, it's a guess. We had no idea how many people will be referred to this program. It could have been a half dozen, it could have been thousands, depending on that criteria. So I think that's the work that the legislature and the department needs to do going forward, is trying to be a little more surgical and putting together what those referral processes will be, and then we can make the program operational.
We did analyze data from the court that Judge Zoni sent us, and the criteria that exist. I think it was around 1,000 people statewide who would be eligible for the program as it currently exists. I just want to emphasize, like, when you give us the positions for a county, whether there's one person on the program or 100 per county, you need that position. So it's being underutilized because of the bottleneck. We could certainly tweak that criteria and tweak the referral process, and then you would see those positions and those resources actualized.
And to add to that, we had it intended to roll to Caledonia County next as part of the pilot project, and then after meeting, this team had been forward. But we've got some work to do, so we halted that process, so we can certainly move to Caledonia County, but there's some challenges coming through first.
And again, through nobody's fault, unfortunately, we had to stop work in April. We would have been able to have all of that and have looked at all those other counties that I was describing by now, had we not ended up with that sort of immediate stop. And then it took us almost a month and a half to be able to get back on our feet, if you will, to be able to do this work.
Questions, comments, folks? Thank you, David. Thank you, Ellen. We really appreciate the time that you've worked in. I also want to thank you for all the work you've done on behalf of the state of Vermont since 2007. It's really been terrific working with you, the Justice Center. You've helped us out tremendously. And I really appreciate you being a partner for the state.
You're very welcome. You remain on my dance card, that's for sure.
Yeah. Big fans.
Okay, so let's get back to our work, upcoming work. In terms of, I know it's 3:00. Are people receptive to sending a memo to the executive branch about renegotiating contract? Recently.
I think it would be helpful, because one, I'm not sure what our meeting schedule is, and I think obviously, given the time constraints of when the current agreement ends, that there's stuff happening right now. It seems like it would be prudent for us to at least identify, maybe the, top, 3 to 5 issues that we want to ensure based upon the testimony we heard today and the, capacity issue within our correctional system, that, we would want to see addressed in any kind of future agreement with the feds around the use of our correctional system, ICE detainees. And I don't know, they were a little, I'm not really sure if, it sounds like it was all under the, I forget what the term was. The border relations, whatever that's called.
CBP.
Yeah.
For what?
It sounded like it was all under the border relations,
Yeah, the MOUs between the state and Customs and Border.
Customs Border
But
Patrol.
my theory as to why we typically call it refer to ICE is because of the overlapping jurisdiction that Vermont has between those two agencies. But I don't really know why it's with CBP and not with ICE.
I think it's been both.
Not according to the.
Well,
that movie
CBP
itself.
has jurisdiction within 100 miles of the border, then ICE has jurisdiction within the interior states.
Right.
But so maybe that.
So that's sort of what I'm getting at, is because of that, maybe it's sort of interchangeable, but it's just not, the MOU itself is not precise.
Daughter, I see your hand up.
Yeah, my understanding was that there was a rider to the CBP contract, which is, so it's attached to the CBP contract, and that rider includes the information about ICE. But that's my last recollection of it. But I mean, are we talking about now what we want to see in this letter, or is that for another conversation before
Well,
August?
if we decide to do the memo today, then what would really be good to expedite this is figure out what do we want to say? What are the 3 or 5 issues that we want to have them address? ensure that they address if there's a new contract. So I'd like to get a feel, does the committee want to do a memo? And if you do, let's figure out what we want in it so that Martin can draft it up in conjunction with Ben.
Well, this isn't gonna affect my viewpoint on that, what you said there, but I don't feel I have enough information on this issue to weigh in one way or another. I mean, I haven't been at any testimony on it. We talked about line, and I have some probably ill-formed opinions from this, hearsay. So personally, I would need to hear more before I was gonna. Yeah, but I know others have been up to their ears on this issue for the past several months.
Ben is pointing to his ear.
Well, I mean, if you want, I can give a very brief overview of the issues that I have heard.
Why don't you come on?
Maybe then discuss, and we'll go from there.
Then we can decide what we want to do. And we can decide about our subsequent meetings too.
Before second.
Okay. You get impatient about 2
I got a
Oh,
o'clock.
meeting to go to.
So bad.
Okay, I'm gonna quickly do my best. So for the record, again, Ben Overgrosky from the Office of Legislative Counsel. Some of the issues that have come across or been brought up by various legislators, is whether or not to actually enter into the contract. That's sort of a threshold issue. And then if there is a contract, to the $180 per person reimbursement does not cover the full costs of incarcerating these detainees for Vermont. So utilizing that amount. Also, kind of the logistics of ICE's operations and how they affect Northwest itself. For instance, there was testimony last session of early morning and extremely late night processing, which overburdened Northwest. They didn't have enough staff. The booking area was overcrowded, and essentially it was really difficult to comply with DOC's own protocols. And so potentially ensuring that there are, in the current contract, if they want to request information about the contract, there has to be at least 24 hours notice, maybe some sort of notice provision about when you're expected to come and bring in people for booking or to remove them from the facility. I think from an operational standpoint for DOC, that was probably one of the most pressing issues from an operational standpoint. And then, more technical issues about who the contract's actually with. Senator, she mentioned the rider. That's nothing that I've seen. I don't know if anybody else has seen this rider or if the administration can provide it. However, just to be frank, the impression I got towards the end of the session was that the more that the legislature inquired about this, the less information became available. So I think that's something for you all to be aware of as well.
I remember hearing about this further back. Of course, it was a few years ago. I think it was a rider to the federal marshal's piece, but then it could have morphed into a contract. Because I did hear that it was a rider, but that was a number, I think we were on Zoom when I heard about this. When we were looking at doing renovations in the booking space at St. Albans, within the Capitol bill, and this was in 21 when we were on Zoom, that came to light before my committee that we were holding folks for ICE. And we heard it was a rider to the contract with the federal marshals at that point, but that was 4 years ago. So that may be, and now it's. Topper, you have your hand up?
You're muted,
You're
Topper.
muted. Just trying to unmute. There you go.
Okay, I'm off mute now. The frankly, the only thing that I'm interested in doing is solving some of the problems that we heard today. The thing that was talked about, whether we should enter into the contract or not, it's going to happen. I don't want to waste my time deciding whether we should or not. The amount of money that comes in for it, I'm perfectly behind that. That should be adjusted. The language problem that was brought up, that should be taken care of. And trying to assemble a cadre of lawyers that handle this kind of work would be something that I'd be interested in making sure happened. And as the representative, I think, was from Waterbury, she talked about the capacity issue. So they're things that I'm willing to talk to the administration about, but I don't know if there's enough time to do it. I mean, do it properly.
There may not be enough time for us to take testimony and work on this. And also, if the administration is in negotiations, they can't be very public during the negotiations time. So it would be difficult. So we're kind of wondering how we could get our concerns to the fifth floor if they're doing some negotiations with ICE over this.
Well, I agree with you, Alice. So I just laid out 4 areas that I think we could put in a memo to them and bring them up as problems that really need to be solved. Because what we're hearing from the corrections department is these people aren't treated any differently than any other inmate. But they may not be treated differently, but the language problem is a big deal. The kind of lawyers that they need, that's a big deal. That needs to be dealt with. And the money issue needs to be dealt with, because if it isn't, what happens is the taxpayers in Vermont are paying the extra money to support the people. And I don't know if that's fair.
So this is
problems right now with trying to get money to do things that are important for the state.
So if we did a memo, which we haven't decided if we're doing this or not, but if we did a memo that would encourage the administration to look at these particular issues. One is the capacity issue within DOC, which also means looking at processing times and the pressure on the booking space, maybe requiring a 24-hour notice of when they're going to move folks out or in. Well, the new contract should reflect an increase in the 180 per person per day cost. That we deal with that needs to deal with the language issue of interpretation to help the folks who are being housed, as well as helping our staff understanding what it is, and also looking at having lawyers available. So that's what I've written down that I've heard. That if we did a memo, we would include these items. Wendy?
Thank you. I think those are all good things if we do a memo. I think we should add something general about complying with Vermont or DOC procedures, because from what I've heard, they haven't.
Well, that's in the
Doing
current,
that.
that is in the current project.
Well, we can just say it again. Maybe they would. Comply. Maybe.
So with this particular brainstorm that we just went through with items that we could focus in, what is the feeling of the committee doing a memo that would lay this out?
As long as it's
I'm not in
limited.
favor of it. I think that they're knee deep in the discussions between DOC, the commissioner, and the governor's office. And I think most of the information that was brought to us by the commissioner and his staff, they know what the problems are. They know what the concerns are. I'd like to think between the governor's office and DOC, they could address these particular issues. I'm not sure of bumping them or attempting to bump them during the process, other than making a statement. That's just my personal thoughts on that stuff.
What I've heard is DOC is not involved in this. Because it's not up to DOC.
I was seeing it more as something where we're supporting DOC. Could support DOC. Where their memo would be supporting essentially the request that we heard from DOC today. Also, to be talking to the government.
Other folks? Nodder and then Topper, your hand, is that still up from before?
Yeah. Yeah, it is, but I do have something. I am willing to do that. As long as we limit it to the things you just talked about. If we get into other things, I don't want to be part of it unless I agree with it.
No, we wouldn't expand it. That's why I wanted to go through what we would include. If we did do a memo, I'd work with Ben. I'd also work with Martin and also Jenny, whether they like it or not. And when we come in with a draft, it would be sent out to all the members here to weigh in on. And it would not be sent until everyone weighed in on it and we had a majority vote to send it. I want to be very clear about that.
And Alice, I think the first sentence of it should be, based on testimony we heard from the Department of Corrections about this, because those 5 things that we talked about, Department of Corrections testified that these were a problem.
Nodder?
Thanks. I agree with the points that you've raised, Alice, as the points to include in the memo, and I'm supportive of sending a memo. I think considering our responsibilities generally, and the fact that this is an issue that's been talked about so frequently and controversially by constituents, at least in Windham County, I've been hearing about it very frequently. We should be sharing our opinion instead of just sitting on the sidelines.
Other folks?
Yeah, just to follow up, thank you, Nader. I'm struggling with the impact to individuals who may have been caught up and weren't appropriately caught up. I do recall being at one of the facilities where we were told that that when someone has been taken by ICE, and then ICE decides, oh, you got the wrong person, or they're fine, they just go out the back door. So they don't even get to go back to, they have to figure out how to get back. And it just seems like, that's not a DOC problem, really. It does disturb the folks who are there to see that, because it's contrary to the idea of justice. So I'm not sure how to put that in this memo. But it seems like we should be talking about fairness to those folks. Because if that was done all the time to all of our residents, I think we'd be pretty upset.
Not to divert us, but it happens in the public inebriety program all the time.
Oh, when people have, I know, that's
Yeah, I was gonna say,
something that I want to talk about at some point. That's a transportation thing.
Yeah, but typically, there really isn't an obligation on law enforcement or the corrections to return people to where they were detained.
No, I understand.
So where are you, Wendy, for the memo? We included those items that we just talked about.
If we are gonna do a memo, those would be the right items. It's frustrating to not be able to include the other part, but I don't think that as a group, we would be able to include the other part.
Trevor? Martin?
Yeah, I support sending a memo. I think what it does for us as a legislative group
individuals, is support for the concerns that have been raised in testimony today. So I don't see a downside to doing.
I know you.
Well, yeah, I mean,
concerned.
there could be a downside, politically for individuals that we're not going far enough, but that's not changing my view on this. I'm also curious, how this would impact favorably or unfavorably on the negotiations. And if I thought that this could help, with the administration's position in negotiation, that certainly, but I don't know that this would one way or another. I think it's written just generally that these are concerns we've heard, and we encourage the administration to take these concerns into account when they're negotiating. I don't think that is harmful one way or another ultimately. So yeah, I mean, depending on how it's proposed.
And Teresa,
I'm supportive.
Topper, is that a new hand or is that legacy?
Can't hear you, Topper.
You're still muted there. No, you're still muted.
Muted.
There, okay. I support doing the memo based on the things that we said. I don't support putting anything in a memo that I haven't heard. And I have not heard any of my constituents talk about the language problem or the money problem or the lawyers. The only thing that I've heard is from the capacity issue. So I've heard all these other things about not being fair and so on. I'm sure everybody has, but I don't think that's should be in this in the memo. I think that's for us to talk to the administration or whoever or our people down in Washington and tell them what we've heard from our people. I don't think it should be in the contract for them.
I mean, I think it just should be limited to what we heard in
Right.
here from DOC, which also means that we can't really, I don't think include there in the memo that we think only Vermonters could be, held there. That, I know that ACLU that's part of their position. We can't really
Right.
advocate their position. We haven't heard from them. So it's really narrow to those operational issues and cost issues that we've heard. Which also kind of makes me think, well, is that kind of milquetoast? I mean, what, not really saying necessarily a lot.
So this is what I've heard, that the memo would start out by being broad and that this, we've heard testimony from DOC and there's some concerns that they've shared with us. And based on that testimony, we would like the administration to take into account these concerns that were voiced to us. And it would be like capacity issues within DOC, which could deal with the processing time and the pressures on the booking. That 180 per person per day should be increased to cover more of the costs for this.
Cover all of the costs.
For all of the costs. Taking care of the language problem, because there's some real issues with language and interpretation. The lawyers be made available to those folks. And that we comply with Vermont, that they comply with Vermont and DOC procedures. That's what I've heard. I haven't heard anything beyond that we would put in a memo. And it would be addressing the concerns that have come to our attention based on testimony from DOC. And we ask the administration to take these items into consideration when they are negotiating. So I'm hearing support to do the memo. Because
Yes.
one, no, some concerns, but I've heard support to do the memo. So let's go ahead and do a memo. Let's do a draft. And Ben and Jenny and I and Martin will sort of, if you could, Ben could send that to the three of us first. So we can look at it, see if it applies with what we just discussed. We may make some tweaks on it, I don't know. If not, or if we do, the committee will then receive the next draft or the draft to see if you'll approve it. If we can do that by email, we'd have a date certain.
You have a timeline in mind as far as when to?
Yeah, a couple weeks.
Is that already done?
Yeah, before it's completed.
It's all done in my head. I just have to write it. Okay.
By Friday, we'll get it out to members at the beginning of next week.
Okay.
And then you'll have a day or two at the most to weigh in, and then if it's approved, and it will take a majority vote, majority of the members to do it, then we can send it all.
Give us a deadline when you send it out to us, Alice.
We will. Good deadlines. Thank you, Ben.
No problem.
So we've got up to 5 more meetings. Do people want to meet in August or take the month off? I'm here. Does it not matter?
As long as it's
Towards the end of August?
On the second part of this.
Do we meet on Wednesdays?
You can meet any day you want. I think Tuesdays is tough for Jen. Was it Tuesday that was tough for her? Was it Monday? Can't remember. And we gotta work, there are some folks who are on another committee nominating. Are you on rules as well? Anyone on-
Elkhart and Johnstown.
Are you on Elkhart? That meets every other Thursday on Elkhart. Are you on Elkhart?
Sure.
Sure. That's every other Thursday.
We'll have a meeting, I think August 10th.
Is that every month?
Not next week. Yeah, 3 days left, 21st, 22nd, 23rd, in honor of this one.
That's July.
I don't know about August.
I'm gone the third week of August.
Let's take off.
Take August off. So I work, and we'll do September, October, November, maybe 2 meetings. towards the end.
That's fine with me. I really do want to make sure that we kind of keep up the focus on the facility issues with DCF, BGS, and DOC on those facility sightings and, next steps and plans. So.
Well, we could talk about some proposed legislation, right? That would get me going.
Well,
Local people.
at some point we may need to, I
We
mean,
need to, and we
you know.
will be the ones to vet it.
yeah.
So I will work with Martin and Jenny on an agenda. We'll also work with Megan to get out a doodle poll for September and October. Oh, God.
Yeah, it'd be good if we could get them all on the calendar.
Yeah. Very smart, I apologize, but I have to.
So have a good rest of summer, folks.
See you in September, October, and November.
See you in September. Oh, yeah, you go, dear.
Yeah, I'm not here.